My name is Robert Seaton, and I'm the reporter appointed in this case, which is an inquiry into the objections to the compulsory acquisition of Plot 37 under the Renfrewshire Council Advanced Manufacturing Innovation District, Scotland South Compulsory Purchase Order 2023. So I see on my screen, I see Mr. Scott Taylor and Mr. Sid Davidson, who I understand are for the objectors, and Mr. McMurray, I recognise, and Victoria Willan as well from the council, I understand. And we don't have Barbara Walker with us. No, not today.
Sorry. Yeah, can you give an update on that? Ms. Walker is unable to attend this morning. She's actually had to, unfortunately, attend a funeral this morning.
Okay, that's right. I've written down I sent out an agenda which I hope everyone's seen. Presumably everyone's seen. Obviously, I've set out my initial thoughts on how things on matters that we need to address today. That you shouldn't take that as constraining discussion. Obviously, my initial thoughts are sometimes wrong, quite often wrong, and also so but what we'll do is we'll work through the agenda and we can discuss those matters. And at the end of the agenda, obviously, there's an opportunity for raising matters that I haven't thought of as well. So, okay. So the first point on the agenda was the scope of the matters to be discussed at the inquiry, dealt with the inquiry, and I've set those out in an annex down at the bottom. This was very much my kind of initial thought on Monday morning, having seen the outline statements of case. I do myself have some thoughts on adjusting it actually. So perhaps we can take a look at that just now. So I listed the need for the council to acquire the objector's site in the absence of a voluntary agreement, and the work proposed to be constructed. I don't know, Mr. McMurray, do you think that those are really taken from the council's outline statement? Okay, so perhaps those are two aspects of the same thing, or perhaps they're just sort of two different stages. And should they be taken together or not? Oh, I can't hear you. You're muted, Mr. McMurray.
Sorry, there's always one. Yes, I think we'd anticipate those would largely be dealt with together. They're sort of one and the same, or certainly related to each other, but with sort of looking at the general justification for why that plot is there and what's going to happen with it, post acquisition, if I confirm.
Yeah. Okay. I mean, well, we can maybe come onto this in discussing the scope of the council's case, but just an initial note, I'm not sure how much evidence we'll actually need on those, because I'm not sure how far the objectors are addressing those. But perhaps we can come on to that when we come on to the objector's case and the council's case. Yeah, just to raise that just now. But so the next part is the effect of the compulsory purchase order on the business of Taylor and Fraser and the Barney Group. And the proportionality of the effect as regards the benefits of the order. I think that this is kind of the burden of quite a lot of the objector's case. Are you content with that characterisation of the case, Mr. Davidson?
Yes, but also I would like to bring in whether there's some issues in the statement of reasons that I don't think are factual, and it's whether the proper guidance has been followed.
But I kind of thought that between that and I'd put the next topic was engagement of the council with the objectors in relation to voluntary acquisition of the site. And would that cover as a topic the issues that you're raising? I mean, maybe to be framed in terms of the compliance with the circular.
Largely, yes. Let's keep it simple.
Okay. requirements for any replacement land. I was thinking replacement land. I was thinking Excambian land there. So I'd put the next two bullets were the requirements for replacement land, and then the proposed arrangements for Excambian of land to mitigate the effects of the impact on the business. So it's 2 points which can perhaps be taken together. Are you content with that kind of characterization of it?
Yes, and obviously it's whether the Excambian land is usable or
well, yeah, well, I suppose yes. I suppose I could add that whether those are satisfactory. Yes.
Yes.
Whether those are really satisfactory. Yeah.
Thank you.
Yeah. Very content with that. Yeah.
Yes, sir.
Good. Okay. And then there was some specifics about the accommodation measures. So perhaps this would be perhaps I've been too specific in some of these. Perhaps it would be better to have a kind of catch-all topic on accommodation measures, and then the council and the objectors can raise what they want to in return in terms of A, what's required for accommodation measures, and B, what's proposed by the council, whether it's satisfactory, rather than focusing on the specific points. Although I think specific points are more or less where what the objectors' concerns are. Is that fair?
I mean, the accommodation works have been agreed in principle, but they weren't agreed in principle until February, which makes me wonder why the council stated in the statement of reasons and its letter to Transport Scotland of the 15th of December why they were well on course to being agreed. It just doesn't. We don't recognise that.
Okay, so the accommodation works are agreed in principle. So do you need to lead evidence on the accommodation works on whether they're satisfactory or not?
My point on the accommodation works is that it's just a further chipping away at whether the council have duly complied with the relevant criteria, and if they have made what I think are incorrect statements in the statement of reasons, then does it hold up the scrutiny the way it is written?
Okay, so in your outline statement of case, you mentioned a couple of concerns about, I think certainly about the position of the security fence and how much of the yard it left you. So the kind of impact on the residual land, perhaps that's captured elsewhere in the topic.
Yeah.
And also you mentioned access, particularly access by articulated lorries to the residual site. Is that? I mean, are those still points for you?
Yes. Similarly, the swept path analysis was given to us in February. So those were all sorted out, but again, they were sorted out several months after I think the council inferred they'd already been agreed. So the focus is not on the accommodation works or whether unfettered access will be provided during the construction, which was part of our concern because we think those have been addressed. The focus is more really on the suitability of the Excambian site offered and the impact on the business of the yard area that is being lost.
So the impact on the Excambian site following the suitability of the Excambian site and the impact on the business of Taylor and Fraser and the Barna Group's land following the accommodation works and in terms of the residual site is what you're focused on, right? So still, I would probably need to know more about the accommodation works that have been proposed and understand how those would work on the remainder of the site. Is that right? To understand the residual effect?
No.
Right. Okay.
The accommodation works are basically a 3-meter high palisade fence, which is fine. It's the fact is that the site at the moment is large and rectangular and works well for the business, and we're being offered what we think is a narrow sliver of land, which is mostly going to be unusable, and it'll be an inefficient L-shaped site that is left and will be substantially smaller than the existing yard at the moment. So that's the issue.
So just so I'm completely clear, when you talk about the insufficiency, the sliver of land, you're talking about that's the Excambian site. It's not the residual yard. No.
What we're saying is that the Excambian land plus the residual yard is substantially smaller than the existing yard, which is the issue.
Right. Okay. So it's smaller, and the Excambian land is a funny shape, essentially.
Yes, because it's narrow. Yes.
Right. Okay. Okay, fine. So I'll need to know more about the Excambian land. That'll no doubt come out in evidence. Good. Okay. I've also put I've also put one further point at the end, an alternative that the objectors suggest is preferable to compulsory acquisition of plot 37. We'll come on to discussing that. We're discussing the objector's case. It was something that came out of your outline statement of case. I've put that in case you are suggesting an alternative, but I'm not sure that is part of your case. I think you're kind of criticising the council's general approach.
I am speculating, and I used to work for councils for 35 years. And basically, when the council do these, certainly when I did them for the councils and Transport Scotland and whoever, you can't go on to the land, you can't discuss with claimants anything. So you carry out an inspection from the roadside. So if you had looked at this site one day, you might have actually seen nothing on it. So therefore you say, oh, well, it's not used. But if you go the next week, it's absolutely full of material. So I think I'm speculating that it looks an easier route through the council than going through another site which had a business on it. But what I wonder if there's lots of what I would say lower grade, in disrespect to them, businesses on Abercorn Street, which only have a few employees, and so whilst those businesses would be extinguished perhaps or have to be relocated, what I'm saying is that the impact on the overall impact on employment risks and whatever would be less had it been elsewhere along Harbour Road.
So do you think that you're suggesting a specific alternative, or is it just a kind of general comment on the council's approach to identifying your site?
Well, what I can do is say that there are numerous less but there are other businesses on Abercorn Street which don't employ so many people, and a alternative could have been for them. I think Mr. Taylor actually just said to me an excellent expression the other day when we were discussing it. I think the council maybe flew a drone over it one day and saw this swathe of land that was unused, and therefore opted to make that the decision in that way. Whenever I worked for Transport Scotland and we did the M74 completion, there were 7 different alignments that we looked on. So what I'm saying to the council is, did you just jump on this because it looked an easier option because you thought the land wasn't used? And the way for the council to close that argument down is to say, no, we considered these other options. Here's what we considered. But obviously, I don't have that information, so it's hard for me to prove what the council did or not do. I'm just speculating on saying that, I think there was a misunderstanding about the use of the yard on the council procedure on the basis that it wasn't important.
This is kind of jumping ahead in the agenda, Mr. McMurray, but what's your response to that? The way I understand Mr. Davison's approach is it's kind of criticism of the council's approach. They're not advancing a specific alternative to the site. So that's a legitimate approach to take, is it?
Yeah, but I think it would be helpful to have that clarity. I think obviously if Mr. Davison is proposing a specific alternative that has various procedural implications that we need to think about. And I know you've got that elsewhere on the agenda. It didn't sound like that to me. It sounded like it was a general criticism of the council needs to explain why it's chosen this this option and what other alternatives it considered, and to put that out there for exploration and discussion at whatever procedure you determine. So which I think is a different situation to proposing a specific alternative, and I'm sure that's something that we can have a look at. And as part of, I think, what we had envisaged by that first bullet point you talked about as to the justification for this plot, we had anticipated that the reasons for selecting this plot would be covered in that part of the agenda.
Because there are a number of alternatives to the scheme discussed in the statement of reasons, but that's perhaps not quite the same thing as Mr. Davison is raising, is it? It's more about the way in which the design of the scheme arrived at this particular site. Yeah.
Yep. I understand that point, and that's something so we can take away.
Yeah. Great. Okay. Right. Is there anything else on the scope of the inquiry? I'll make some changes along the lines that we've discussed, and then obviously, if you still disagree, if you disagree with what I've written, then you can comment on that further. Right. Okay. Representation of the parties. Well, I think this has been dealt with in correspondence. I know that the council is going to be represented by Mr. McMurray and Barbara Walker and Victor Francisco Suarez, and representatives unspecified yet from Amy are to be witnesses of the council, and the objections we represented, both the objections represented together by Mr. Davison, and their witnesses will be Mr. Davison and Mr. Taylor, who's here. Okay, I don't think there's anything else on that point. So moving on to procedure at the inquiry. Now, I think I set out in the agenda that the normal, well, I've been appointed to hold an inquiry, and the normal procedure of inquiry is for parties to be able to present evidence through witnesses and each be able to cross-examine each other's witnesses, and that's certainly what the inquiry rules indicate would be the normal procedure. I don't know how far. I suspect I don't have much room to derogate from that unless by consensus of the parties. The council has suggested that a roundtable hearing session might be better, might work better, or suggested that that's what their preference is. Mr. Davison, do you have a view just before you comment? I mean, an inquiry with cross-examination does present certain difficulties to you, obviously, in that you're a witness as well, and it will be difficult. Not normally, well, I'm sure you're very familiar with an inquiry situation in which evidence in chief is taken by the representative from the witness, and the representative, to a degree, protects the witness, can object to unfair questions. For Mr. McMurray wouldn't ask unfair questions, but so terrible things can happen just on the spur of the moment. and then there's re-examination as well. I mean, are you content to be able to run it as an inquiry nonetheless, or would you prefer a round table discussion?
I suppose the difficulty from my side, if I'm a witness who's going to ask me the questions that I would like to be asked.
Yeah.
So, for whether it's acceptable for me to stand in a soapbox and say, "Here are my questions," and then put on a different hat and answer them, it's a bit artificial. So, if a round the table meeting would enable that to happen more easily, then so be it. Because the difficulty is, if I put myself in as a witness, and then the counsel don't ask me the questions that I would like to be raised, then that opportunity is lost. So
yeah. So you're content that if you want to raise questions to the council, you can put them through me, and I will generally put those to the council in a kind of roundtable discussion situation.
It's really the questions to myself.
Right.
To be honest, it's true that I can lead the evidence from my side if so really I would like to have questions, and if you're willing to have those questions for us, which would my questions then posed to me as a witness, then I would be. Can it work?
I have to run a fair procedure. So if effectively the council are restricted in cross-examining you, or so you'd still like to be able to cross-examine the council yourself, yeah.
Yes.
Witnesses,
but if some of the issues that I would like to raise aren't raised by the council in their own evidence or cross-examination of me, how do I get that out to fully represent our case?
There's in terms of written submissions before the inquiry, obviously that their documents are submitted 4 weeks before the inquiry, I've suggested. Then there's a recognition of witness statement 2 weeks before the inquiry. So in theory, a lot of the evidence should be in writing. Sometimes, quite often, the friendly questions, the examination in chief, so that the questions are supposed to arise from matters that have come out of the recognitions of other witnesses. So perhaps what could be done if we're to retain an inquiry format is that you could make a short statement in response, an oral statement at the beginning of your evidence in response to the evidence in other recognitions. Would that be? I mean, Mr. McMurray, would you be content with that kind of approach?
Sorry, if that is the approach suggested, I don't think that poses any problems for.
Okay.
So my one question would be in the issue of re-examination.
Well, that's right. I was going to come to
that would work, but that's obviously a separate matter. I've no issue with the sort of short statement update addressing points raised in other people's evidence as the start of Mr. Davison's examination in chief. I don't think that poses any difficulties.
Yeah. I think that's as Mr. McMurray says, that's the other aspect of it, is that usually there's examination in chief of witness, so open questions are asked about the evidence that come out of other witnesses' statements. You're then cross-examined, and then at the end you're asked questions, hopefully to repair any damage, to draw out to points that have been raised during your cross-examination. I'm not sure if there's any way of addressing that by any further means. I don't know if anyone has any suggestions. Mr. McMurray, have you come across anything like that before?
No, it's when it has been raised before, so it's always been the re-examination that's caused greatest concern rather than the examination in chief. And I wouldn't want any suggestion or any intention that there'd been some sort of prejudice to the evidence because there wasn't an ability to re-examine the witness in there, which obviously we are keen to avoid for any suggestions or questions over the process.
Yeah. Well, obviously that there's an opportunity to make to give written closing submissions at the end of the inquiry, which may and they don't relate to matters of fact haven't been raised during the inquiry, but they can address points of law, points of policy, and the evidence that has actually been given. Yeah. I mean, are you content to forgo re-examination? That's really. I'm not sure if I can see a solution to it.
No, well, that is from our point of view, it is a solution. If I'm going to bring matters in that aren't discussed during the inquiry before the closing submissions, then I can raise things about whether the British Line circular and CPOs has been, properly, the spirit of it has been adhered to or not, the impact of human rights versus the individual human rights versus the overall public benefits. Those can all be brought in then.
Yeah, that's as a matter of law. Yeah, it's matters of so really sort of factual matters that are subject to contestation and evidence that are that you wouldn't be able to draw those out in re-examination.
Well, if there are closing statements, then there's no opportunity for the
you can't introduce new evidence in closing statements. Yeah.
But so my problem is if I can't ask myself, obviously, a question about introducing whether the best practice guidance has been adhered to or not, and the other items that flow as a result, then that represents a difficulty. It's just how do I get those out?
Re-examination is something that comes out of the cross-examination, essentially. So it's questions that are questions from that your representative would want to ask about matters that you've been cross-examined on. I mean, you can only really be cross-examined on the evidence you've already given, on the written evidence you've already given.
It's just if I'm not asked questions, does my submission then you just rely on that? If no one elects to cross-examine me on whether best practice has been complied with or not, do I just let that rest and you then revert to my statement? The reasons.
I think well, bearing in mind that we've said that you can make a short statement make a statement at the beginning of your evidence, responding to written evidence of other witnesses. And then you would be cross-examined on your evidence, including the short statement the statement that you've given.
Okay, no, all right, and that's fine. I can work with that.
Well, the alternative is that the objectors have someone in addition to yourself who is a legal, who will represent the objectors and ask the questions. I know that is an alternative, and perhaps it's one the objector will want to consider.
Yeah, it's obviously the cost of that when you don't get the cost back for objecting to CPO. That's an issue. I can discuss that with Mr. Taylor, but it can be very expensive.
Yeah. Yeah. Well, I'm sorry, I haven't looked at the issue of cost, but I don't think that quite characterises how these things work. I think you wouldn't get them back if you were unsuccessful. I think.
So you don't get costs back for objecting to a CPO. So, for example, our discussion today is costing Mr. Taylor my time, and he won't get that back from the council by way of compensation, irrespective of whether the CPO is approved or not.
Just a moment. Let me come back on that point later. I think we'll take a look at that. So in terms of procedure, are you content with a process in which you will lead out Mr. Taylor's evidence? You'll ask him questions in chief and re-examine him. Then you'll give a short statement in your own evidence, and then be cross-examined. And then there's no opportunity for re-examination. You're content with that, or at least that's
yes. There's obviously quite a few things that I would like to be cross-examined on. So without knowing what questions the council are going to ask me, how long is my spiel going to be before I give my when I come forward as a witness, you say I get a short statement.
I'm sorry, I shouldn't have said short.
Well, that's fine. That's fine. If it's adequate, I won't be too rambling. But it's just I can have them bullet points to edit it down. But that's fine. That's fine. I can. That's fine. That's fine. If it's not going to be curtailed to 250 words or something, then I.
It was merely a mental saying short.
No,
I'm sorry.
I would hope it was short as well.
The point is, it's as long as you need to respond to matters that have arisen in the written evidence of other witnesses that haven't been that you feel you need to respond to and that aren't adequately dealt with in what you've written already.
Okay, that's fine. That's fine.
Yeah. So we'll, Mr. McMurray, are you content with that approach? I mean, I hear your concerns about the lack of re-examination or the lack of opportunity for re-examination. But it appears the attackers are content with that.
Yeah, I think initially our suggestion was the hearing was based on the topics that we thought were covered, that we didn't think there was anything sort of very technical that required cross-examination, and that hearing with a roundtable discussion would have been the most appropriate. I think having heard the discussion this morning, I'm even more convinced that a hearing would work best, just given the difficulties on re-examination. But ultimately, it really is down to the objectors on this point and yourself. The council probably has very limited opportunity to influence that at this stage.
Yeah. Well, I have to say I don't disagree that a hearing might be sort of more effective and fairer all round. But if it's the objective position that an inquiry is to be held, then I don't think I've got discretion to derogate from that.
Well, I understand that, so that's understood.
Is this the so a meeting in person? You're saying would that be different from an inquiry, or is it? I thought it started to be appear silly here, but are we not talking about the inquiry will either take place in person or by Teams?
Oh, I'm sorry, I'm confusing. We were still talking about the procedure. And I was asking Mr.
That's right.
McMurray whether he was content with the procedure that we had discussed.
Oh.
We talked briefly about the council's position is that it would prefer a roundtable discussion without leading evidence through witnesses. So it would be all the witnesses and the representatives round one table. There wouldn't be cross-examination, but questions would be asked through the reporter about the other side's, or through me, about the other side's evidence. That kind of procedure can be more effective in some instances, but it's not the procedure allowed for that's provided for in the regulations on compulsory purchase. In my view, it's possible to go to that kind of procedure, but only if it's the consensus of all parties. And I think what I'm getting from you is that it's not, you wouldn't be comfortable with that kind of roundtable procedure. You do want to cross-examine the council witness.
Yeah, I mean, if our view is that the Scottish Government guidance hasn't been complied with, and there have been misstatements made by the council in the statement of reasons and its subsequent correspondence, then I think I would like to question the council about that.
Mm-hmm. Okay. Right. Okay. So, yeah, I think the other question I had on the procedure at the inquiry was the order in which things would take place. I think it would be normal for, well, there are different ways of doing things. We can hear evidence topic by topic, or we can hear evidence, the whole evidence of one party, and then the whole evidence of the other party. Which do you think would be more convenient? I mean, I don't have a strong view on this, but I suspect that it would probably be easier just to hear the whole evidence of one party than the whole evidence of the other party. What's your view? Either of you? Well, let's start with Mr. McMurray.
So I would agree with that analysis. I think realistically there are going to be some witnesses who will be probably covering a range of the topics. Mm-hmm. So if we were to go by topic, we'd probably have witnesses coming sort of back and forward onto the sort of the witness stand, so to speak. So it seems to me to make sense that we dealt with it by sort of party by party rather than topic by topic.
Right. Okay. Mr. Davison, what's your view? Oh, you're muted, Mr. Davison.
I would agree.
Okay, good. Right. And that's just one other question. I think actually, perhaps it's to cover in the next thing. I just want to understand what evidence each witness is giving. I don't think that's been specified by either party. Perhaps we could deal with that now. Ms. Davison, how are you dividing up your case between yourself and Mr. Taylor in terms of the evidence?
Mr. Taylor would be able to talk about the suitability of the Scambian site, and how that the one site that the council have finally offered, how that would not work for the business. Mm-hmm. He may also want to, there's been a few developments since your initial invitation, and that Mr. Taylor himself has found a site, and that might work. It's still early days with that one, but if we haven't got an agreement by 27th of August, it may be something that Mr. Taylor could all talk about. Mm-hmm. But otherwise, I think the intention would be for myself to deal with most things. And actually, now that I think about it, any issues that I want gone in. If I was a witness, how can I ask myself the questions? Well, actually, I can ask the questions by asking them to the council's witnesses.
When indeed, yeah, you can
So,
get out
so,
those witnesses.
so I finally worked that out. So yes, yes, so so I would be a witness to the other events, and I probably would just not say anything else. I might actually just probably put myself forward as a witness, and if the council want to ask me any questions, then they can. If they don't, then they don't, because hopefully I will then cover them and the questions that I'd asked to the council, assuming that I went first. Sorry, no, second.
After Mr. Taylor, you mean? Yeah.
No, it depends whose evidence is going to be led first of all.
That's a good point. Is it not normal for the council to go first, or the objector? No, it's normal for the objector to go first, I think, isn't it?
So I have seen it both ways. I think more of the occasions I've seen the acquiring authority lead evidence.
Okay, yeah.
First, but I think that there's scope to do whichever suits the particular circumstances.
Well, should we say the acquiring authority in this case would lead its case first, and then the objectors? We'll go with that.
Yes.
Okay. And Mr. McMurray, how are what are your witnesses speaking to in particular? We've got 3 witnesses.
So we've only had some initial discussions about how we're going to allocate that. I know you've made provision, and which I fully agree with, and we'll come on to in terms of the sort of fuller statement of case, and we can to setting that out and that.
Okay. Well, that's grand. Okay. So in terms of, we'll move on to that topic now. In terms of the likely content of the acquiring authority's case, so we've got sort of heads of terms. It's perhaps a bit fuller than I'd thought when I wrote that, which was perhaps a bit unfair on the council. I didn't take into account fully the response to the objection, although that was provided in 2nd December. But yeah, I think it would be helpful to have further specification on the council's case on a number of matters. I had thought various accommodation works would need specification, but I understand the accommodation works are agreed, so we won't need that. But it would be helpful to know about the Cambian land that's been offered, because I don't have specification of that. It would probably be helpful for me to know what the residual site would look like following accommodation works, so that I can understand the residual effects on the site and the council's view on the degree of those residual effects. Yeah.
Awesome. Understood that.
Yeah, great. Okay. And content of the objector's case. Well, I think I understand this. You've given quite a full statement of case, and I understand that your case is, well, you've got you've described your case to me, and that's fine. We've talked about the question of alternative sites, and I think we've covered that topic.
Without being pedantic, there's only ever been one alternative site offered by the council. Nothing else. No assistance with looking elsewhere for other sites.
Sorry. Just to be clear, Ms. Davison. Sorry, I wasn't talking about an alternative site for Excambian. I was talking about
alternative route.
the objectors have alternative route, and indeed that's right.
Right.
Yeah,
Okay.
yeah.
Fine.
So in general terms, your criticism is of the council's procedure. You're not proposing a specific alternative site, is what I understand from today's discussion. Unless you want to go and consider that further.
I can give you a map showing an outline of Abercorn Street linking over to Harbour Road, and say you could take any other site, almost bar Mr. Taylor's.
Mm-hmm. Yeah. Don't think I would need that. I mean, I can understand. I can understand that. Your position. I think without a map showing.
Well, that's fine. That's fine. That's fine. But it's just if I have to, demonstrate where there's internal plot, it could be anywhere, and the best way for the council to, take my argument away. I know this from working for the acquiring authorities, is to show that they consider alternative routes and why this one was the one selected. Our speculation is because it looked as if it wasn't used.
The point is, you're not proposing a specific alternative. It's simply you're saying there could have been other alternatives.
Yeah. I could give you Pacific alternatives if I got a road width and then applied that the whole way up and down Abercorn Street.
The point is, Mr. Davison, is procedurally, I would need to know what alternatives you were suggesting if you were to suggest a specific alternative. It's a requirement of the law of the rules. But I would, if I am to consider an alternative as a possibility then I need to know what that alternative is.
So you're saying it could be anything on
Abercorn
Street.
I understand.
Is that sufficient or not?
No, I don't think so. No, I think that the law says I would need to have a specific plan, identification of the land that you're referring to.
Yeah. Well, I'll get you a plan with and annotate various different options on it.
All right. Okay. What does that mean for us procedurally, in your view, Mr. McMurray?
So in terms of procedurally, I think I agree with your interpretation of what the law requires. If there was to be a specific alternative proposed, then that would need notification on owners of that alternative land to give them an opportunity to participate in this process, which potentially knocks has implications for everything we're discussing this morning.
Well, okay, can I jump in there and say, if that was the case, then for Mr. Taylor to maintain his good relations with his neighbours, he's effectively saying, well, it can go somewhere else as long as it's not on mine. Then in my questioning, I can then focus on why this alignment was selected and ask questions, so we can drop the alternative route. I can get that out that way.
Right. Okay. So they're not proposing a specific alternative, simply a comment on the council's procedure in terms of how they reach the view that Mr. Taylor's site should be.
Well, I can ask them what alternative routes should you consider and how many, and if they say none, then I've demonstrated they haven't considered alternative routes, I would hope. But thank you.
Understood. Right. Okay. So, is there anything else on the scope of the content of the council's case or the objector's case that I should raise that I haven't raised? Well, sorry, there is one other point on documents. Or it's a couple of other points I'd noted. One is on documents. It would be useful to have a list of the documents that the objectors intend to rely on. But in particular, you've mentioned a couple of inspectors' decisions from England, and it would be helpful to have copies of those decisions. And it would be quite helpful if you could circulate those as soon as possible. or just give us the references. That would be quite useful. Other thing that I'd noted but that isn't down on the agenda is, I was wondering, in terms of the benefits of the scheme, the council sets out a number of benefits of the scheme in the statement of reasons. I don't understand, but the objectors haven't raised anything about the benefits of the scheme. Leaving aside your concerns about how your site has been identified, are you actually arguing? I wondered the degree to which we actually need oral evidence on the benefits of the scheme if you're not saying that anything the council is saying is wrong. Oh, you need to unmute Mr. Davison. Unmute Mr. Davison.
Beg your pardon. I'm pretty sure in my statement I did say that we agreed that there were public benefits.
Right. Okay.
But the difficulty, or what it is is it the human right implication upon Mr. Taylor is something we would raise, but I don't think we would dispute the public benefits. It's a major regeneration scheme, but so I don't think we would be done that way.
Yeah. So Mr. McMurray, in terms of the benefits, obviously the benefits are set out in the statement of reasons, council statement of reasons. There is perhaps an issue about the proportionality of the impact on Mr. Taylor, which may require you to refer to the benefits, but presumably you're not going to lead extensive oral evidence on what the benefits are.
No, if Mr. Davison, and that was a helpful confirmation, I appreciate that from Mr. Davison. If that part is accepted, then I don't think it's a good use of inquiry time to just lead lots of evidence discussing something on that's agreed. So yeah, we will avoid that. We may still need to, as you say, make reference to the benefits, and it may well be something that we cover in closing submissions as well as part of the summing up. But we would not leave detailed evidence on the benefits if it's agreed.
Great. Okay. Is there anything else on the likely content of parties' cases that I should have raised that I haven't raised, or that people would like to raise? Nope. Okay, good. All right. The next thing was scope for agreement of facts between the objectors and the council. I'd mentioned, I think one of the objectors' key concerns is about engagement, and I thought it would be very helpful to have an agreed timeline of engagement with references to the documents generated. Is everyone happy with that? And it'd also be helpful, obviously, to have the plan and details of the Excambian, or the council's proposal for the Excambian land. And if there's an alternative potentially for Excambian that the objectors have identified, perhaps it would be helpful to have identification of that too. Yeah. And in terms of the requirements for the Excambian land, yeah, is everyone content that can those be agreed to, and or at least if you could set out what's agreed and what's not agreed on that would be very helpful.
There's a disagreement over the net effect of the loss of the land being acquired.
Right. Yeah.
But irrespective of whether whose side you come down on there, the Excambian land as offered, with or without this differential, is still substantially smaller than the area being lost.
Right. Would it be helpful? Would it be possible for you to agree a statement with the council so that I can understand the precise extent of your agreement on the and disagreement on the Excambian land?
I mean, I started to write out a timeline, and I'll maybe send that to Victoria. This is a starter for 10, and just to say, well, you know, is there anything here we disagree with, and then we can build that up as necessary. So, so that's something that I've already started on.
Yeah, no, that sounds good. So, look forward to receiving that.
That's great. Okay. And obviously you're agreed on the accommodation requirement, so it'd be useful if that could be covered to be set out in a statement of agreed facts as well, just so that I can understand what's been agreed in terms of accommodation arrangements and what, and in that context understand parties' evidence on the impact of the Baltic purchase and how the residual land will work. Is that okay? Or is it clear?
The accommodation works really aren't the issue.
No.
The residual land working, it's the size of the retained land plus the sliver of land that the council are offering. But we're hoping discussions regarding this alternative will overtake them.
Yeah. It's simply to understand your evidence. I would like to visualize as far as I can the residual land. So it'd be useful if you can set out.
Happy to do that, and you are going to carry out a site inspection, which is probably the best way to see it for yourself. But yes, it's something I'm sure Victoria and I can
actually
a statement to go.
Since you mentioned site inspection, I noticed that during the council site inspection on the 19th of December, the area to be the area that was subject to the order was marked out. And it would be very helpful if during my site inspection, it could be the land subject to the order could be marked out. Is that possible? Mr. McQuarrie.
I think that would be sensible. And obviously the land's obviously within the control of Mr. Davison's client, so assuming they're happy with that, I think that would probably make sense and would bring most benefit to yourself.
Yeah. Okay. Is that you're content with that, Mr. Davison? Would you be able to arrange that?
Yes.
Great. Okay.
Sorry, here. Can I say a few words?
Of course you may.
We took an assumption that the land that you are trying to acquire was of a given size, and we estimated it was on a range of about 40 metres of a strip. Now that could be wrong. So if we could be given a more up-to-date drawing of what the proposals precisely are, we will mark that up in time for your visit to show precisely rather than our estimate of what is required.
So I think Mr. Taylor would like a plan, Victoria, the CPO plan, but you could put linear measurements on it, on the boundaries, so that it can be accurately marked out.
Yeah, I can ask the technical team for that and get that to you for the site visit.
Thank you. And then, Mr. Taylor, when the council come out to market, you can both together just agree that it's been marked out in the right place. Is that?
Our access road has been totally lost under the new road, and so we've got to create another access off Abercorn Street, because we obviously can't drive through the construction works. And what we're left with is a quarter of that site. All it's going to be left for us is a quarter. When the work is complete and we can then get access off the new road, then we will get half back again. So it's, I know you're talking about the potential of, we've found a site, as we all know, further up Abercorn Street, which is a veritable jungle at the moment. You're liable to be eaten by a tiger there. But it would be great if I know that Sid has passed details of what it would take to knock that into shape. And that's something that couldn't be done overnight. So it would be a great help, really, if there was a decision made to reimburse us to create that site, the owner, Bridgeway Leather Company, will not sell it, they'll only lease it, and they've been very accommodating towards us in this whole process. So an early decision, if we could recover the cost to develop that into a suitable storage area, would be great. If we wait till September or end of August when this inquiry goes through, that doesn't leave a hell of a lot of time until works presumably start.
Just so I can explain, Mr. Seaton, right, because it's going to cost quite a lot of money to bring this land up to a usable standard, and it's going to be leased, and unfortunately it's not going to be a long-term lease. So I have my concerns about whether it's a long-term solution. But let's say Mr. Taylor can negotiate a 10-year lease. After 10 years, what we are hoping to say to the owners is that all these benefits will fall to you, so therefore you should reflect that in the lease terms, the rent to us. So, but we don't want to go to them and tell them that it's 85,000 or whatever it costs until the council have agreed the principle.
Mm-hmm. I think these are maybe matters for discussion between yourselves and the council, rather than something to come take to the inquiry.
In defence of the council, I was contacted by their agent this week, and he popped out and he saw the site on Monday with Mr. Taylor. So that is moving forward.
Yeah, sorry, just to echo that. So I appreciate Mr. Taylor and Mr. Davison for setting out what their concerns are, and the council will take them away and as part of the discussions which are ongoing between the parties, and which will hopefully be resolved in due course.
But it's helpful, and it's always helpful to mention these things just in case, because obviously the agreement is always going to be better than an inquiry in terms of costs for parties. Okay. In terms of time to present parties' case, the councils said their case would take about a day. That sounds about right for three witnesses. I would guess, Mr. Davison, do you have a view on how long? And obviously, it depends on how many questions you're asked. But do you have a view on how long your evidence might take? Would it be another day, perhaps? Oh, you're muted, Mr. Davison.
Apologies. Again, it effectively the only evidence that we will be giving is from Mr. Taylor. If the majority of my evidence is effectively going to be put through questions to the council's witnesses, then my evidence, I'll offer myself as a witness, but if I can't ask myself questions, then I'm relying on the council asking me questions. So it really depends.
Well, but don't forget, you would have an opportunity to orally, in a statement before your evidence, to respond to matters that have been raised. So that would be part of the time that you would be taking.
But I would surely have the opportunity to, if I'm cross-examining the council's witnesses and asking questions, then I'm almost doing that at that stage.
That's part of the estimate of the council's time. Certainly.
Well, I can't see it taking a day. I would speculate, a morning, but I think if they maybe best on the safe side to go for a day as well. I can't see it being more.
Okay. All right. So we'll say perhaps 2 days overall for the inquiry for the council's evidence, and then the council's evidence, and well, we can hope that it'll take a bit less on the at the time. Okay, and the inquiry date. I set down 27th August, starting at 10 a.m. Is everyone content with that? Yep, it's excellent. It's good. That's never happened before. And is everyone content to hold the inquiry virtually, or would you prefer to be in a physical location?
From the council's perspective, so I mean, they're satisfied with a virtual procedure.
Right. Okay. And
Yeah.
Mr. Davison?
Yes, we're happy with that.
Okay. Splendid. Right. In terms of timescales for the various submissions, it would be helpful. And I've set out timescales there. So timescale for full statements of case on the 4th of July, for documents to be referred to by parties on the 30th of July, the agreed statement of fact on the same date on 30th of July, and precognitions on 13th of August. Is that sufficient for everyone?
Yes.
Are you content with that, Mr. McMurray?
Yes, I think those timescales should work. I mean, like the one comment I would just make is that there may be various council people caught up in various election activities over the next
of course,
few
yes,
weeks,
yes.
which might occur. But as things stand, we think that's achievable. But obviously, if something does occur, which takes up time of the various people putting into the statement, so we will flag that as soon as possible.
Oh, that's perfect. I mean, if you could flag it in advance, just so that there's, so we don't end up with a situation where people are putting in things uncoordinated. So the objectors make a submission and the council finds it can't. Yeah.
Absolutely. But as things stand, so we think that there shouldn't be any problem with that. But just obviously, just in case something changes.
That's excellent. Okay. Well, I've set out what I was asking for in the full statements of case, and I think we've discussed that. The objectors obviously have given me information on a couple of those points already that I've raised. But I don't think there's anything else to say on the full statement of case unless anyone's got anything to add to that. No. Good. Documents. Well, I've set out the purpose of documents there. And it would be helpful if it's council content to prepare a common document list, so that we're not having duplicates submitted. Do we need to in this degree of inquiry?
Yeah, I mean, we've certainly outlined the case proposed an initial set of core documents, which we would expect both parties to be referring to. Obviously, if Mr. Davison has any additional ones that he would like to add to that list on behalf of his clients, then we'd be happy to add them to the list as well.
That's great. Perfect. I mean, in particular, if you could add those two inspectors' decisions, that would be very helpful. If Mr. Davis, you will specify what those were, what their references were.
I will do.
Great. Okay. Recognitions, I've essentially set out what a recognition is for. I think that's generally fairly well recognised. So if it's if it's more than 2,000 words, I'd usually expect a summary of the recognition. The site inspection, is it everyone content with arrangements on documents and recognitions?
It won't suit me. It's we're away at that time. If it was 2 or 3 days earlier, it would suit me.
Oh, for recognitions. For the data recognition.
Was this the site visit? I thought you were.
Oh, the site inspection. Yeah. Okay, we'll move on to the site inspection. That's grand. Yes. So 20th of August is not convenient, but several days earlier would be.
Maybe on somebody else. Would it be? If you particularly want me to be there, I think we go away on the 18th for a week or something like that. Right. So if it could be a little bit before that, would be great.
I'm very happy to make another date. The only reason I specified a date was simply I find it's easier just to specify a date, and let everyone react to it. So if you have a problem with that, I'm very happy to move it. We have so a couple of days earlier. It's probably good to do it fairly close to the inquiry.
I think we go here Sunday the 18th. The 18th of Sunday, is that correct?
Yep.
It is, yeah.
So it needs to be the previous week, the Thursday, Friday, whatever, Wednesday, Thursday, Friday of the previous week.
So if we said maybe Thursday the 15th, would that be convenient for everyone?
No problem.
Maybe same time at 11 o'clock, would that be convenient? Perfect.
That's the 15th.
15th, yeah. 15th of August.
Sorry to upset the thing.
No, not at all, Mr. Taylor. This is what these meetings are for, and it's as I say, the only reason I set a date is so that you can see whether it's, if everyone's happy with it, then it's fine, and then if they're not, then we can move it. Okay.
So I will take that away and confirm that with the representatives. I think it should be okay, but I will follow up after the meeting just to confirm that.
That's perfect. Yeah, and it's just the school holidays are just over, so hopefully people will be back.
Yeah, that was my thinking too. Sorry.
Yes. Right. Well, we've discussed perhaps marking out the site, but it would be very helpful if you're able to do that for the site inspection. And closing submissions, I think. Yes, I mean, it's a fairly standard arrangement to have closing submissions, so you can make submissions on points of evidence that's been heard, and on points of fact and law, and the application of fact and law to the evidence that's been heard. And are the arrangements for closing submissions acceptable? 2 days after the inquiry for the objectors, and then 2 working days after the inquiry for the objectors, and then 2 working days after that for the council. Is that sufficient? Yep. Okay.
Yes. So yes.
I think Mr. McNair's nodding his head too, so that's grand. Good. That's agreed. And is there anything else that we haven't talked about that we ought to have talked about today?
Not from my perspective.
Yep.
Yeah.
Okay. Well, that's excellent. Thanks very much. Well, I'll get you out a note of this meeting as soon as I can. And if there's anything I've got wrong, please come back to me as soon as possible in writing and let me know what I've got wrong, and we can sort it out. Okay.
Thank you very much. Thank you very much.
Yes.
Thank you, everyone.
Yes,
Thank
thank you.
you.
Thank you, everyone.
Thank you.
Bye-bye.
Bye.
Bye.